Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case of St. Peter versus Pioneer Theater Corporation. This case was heard in the Iowa Supreme Court in the year 1940. Let's go ahead and jump into the facts of the case. So St. Peter, the plaintiff in this case, was at a Pioneer Theater bank night. A bank night was basically a glorified giveaway. It wasn't a lottery because you didn't have to pay to get your ticket entered into the lot, but ultimately if you stood by the theater and you got a ticket, then you were entered into the lot. The plaintiff in this case is a husband and a wife. The wife, the number of the husband was called. He had won $275. He was thrilled. The wife heard that the husband's number was called, so the wife went to the front desk, tried to claim it, and the guy said, "No, actually, your husband needs to be here." So she tries to go get her husband. By the time her husband gets there, there was a 3-minute deadline for claiming the award had passed. So the Pioneer Theater employee said, "Hey, sorry, you actually don't get the $275. The plaintiff said, "Well, this is ridiculous. We're going to sue you if you don't give it to us." And they did, and that's where we're at. So this case was argued in the trial court and the appellate court, and in both instances, it was ruled in favor. The court ruled in favor of the Pioneer Theater Corporation. The Pioneer Theater Corporation's argument was that if the court was going to rule in favor of the defendants, they would have to call them a lottery, and they're not a lottery. And then furthermore, it was just that it was merely a gift. There was no bargain for promise in this instance. It was just a gift. The $275 was a gift, and this contract couldn't be enforced in a court of law. The defendant was very cocky, even in the interaction, said that the law is on our side. You can go ahead and sue us, but the law is on our side. So the issue in this case is, was the bank night lottery sufficient? Was it, in essence, a contract? Was there a bargain for exchange between the two parties? And the court ultimately grapples with this for a while. It's not a short decision, but they ruled that it was a unilateral contract. So a unilateral contract, the court says, is in a unilateral contract, only one party makes a promise. If that promise is made contingent upon the other party doing some act which he is not under the legal obligation to do, or forbearing an action which he has legal right to take, then such affirmative act or forbearance constitutes the consideration for and acceptance of the promise. So in this case, the court held that it was a unilateral contract because St. Peter, the plaintiff in this case, and for that fact, anyone who was at the bank night, was giving up their freedom to be somewhere else. They were staying at the theater, and that was the bargain for consideration because they had given up their liberty to do other things. The consideration in this case was based upon the plaintiff and all the other patrons of the bank night surrounding the theater. So that's the ruling. It's a unilateral contract, and just to further reiterate that, a unilateral contract is a contract where one party gives something up in exchange for a promise, whereas a bilateral contract would be a promise for a promise. So this is a unique scenario here. Let's go ahead and jump into the ex ante implications. I think the ruling is good because it ensures that giveaways can happen, right? Like if the court had ruled in favor of Pioneer, the giveaway system as a whole would have basically gone down the toilet. I'm thinking like YouTube, Instagram, Twitter, all these people who give away things to get followers. Some people even give away Teslas to get followers now. That wouldn't be possible if there wasn't any type of legal enforcement, because everyone would know that they're just a sham. It's a scam job. But ultimately, the action of the person who enters that giveaway is enough to constitute the consideration. So in instance of YouTube liking the video, or Instagram liking and commenting whatever the person asks you to do, maybe share the post. If you take those actions, that's the bargain for consideration. That's what the court would rule was the consideration in this case. So, if someone said, "Hey, like and share this post and we'll give you a Tesla," and then you like and share the post and you're the chosen person to get the Tesla, but the person ultimately reneges on the deal and says, "Hey, sorry, we're not going to give you a Tesla. That was just a gift." You actually do have a good contract there, and it's valid underneath the precedent set here. And also, just incentivizes people from not being bad actors and misusing giveaways and getting people to like their, in the metaphor here, like Instagram posts, YouTube videos. In the case back then, stand around a theater and give that theater attention for nothing. There is bargain for consideration because the person acted and liked the video or withdrew from, doing something else that night. They stayed at the theater rather than going out and getting dinner or just staying at their home. So thanks so much for watching. If you like these videos and you'd like to see more, go ahead and subscribe to the channel. Hope you have a nice rest of your day. Bye.